Today in India, there is what I'd say the old Section 65B certificate still idea still exists because but now it sits in the Bharatiya Sakshya Adhiniyam 2023, which came into force on 1st July 2024. So the basic rule is very simple: the contents of an electronic record, like a WhatsApp chat, are not treated casually just because they are on the screen. So if you're using a computer output or a screenshot or a printout or for example exported chat, so the law asks for a certificate that explains what the record is, how it was produced, and what device or system it came from. So the current statute also recognizes that an electronic or digital record produces from proper custody, which can itself be primary evidence unless it is disputed otherwise. So the easiest way to say this or say it is this a WhatsApp chat can be an evidence, but the court asks that is this a real chat, or who made it, or where did it come from, and can we trust the path by which it reached the court. So the Supreme Court in Arjun Pandit Rao Khotkar made it clear that the secondary electronic evidence needs the statutory certificate, while also clarifying that if the electronic record itself is produced as a primary evidence, then that certificate requirement does not apply in the same way. So, in simpler words, in other words, the law does not reject the WhatsApp chats, it insists on proving them properly. So, the nuance over here is that in NDPS cases, a chat may show the intention or a communication or a contact or even the planning of something, but that is not always the same as proving the possession, or rather recovery or consumption or conscious involvement by itself. So courts have in NDPS matters refer to WhatsApp chats together with bank transactions, or rather device data. And in another NDPS order, the Supreme Court noted that few WhatsApp messages plus a retracted statement left a very little other evidence. That is why your instinct is directionally right, that chats are uh, uh, often a powerful corroboration, but the safer legal position is that their weight depends on the full chain of proof around them. The precautions a court can take are very practical and strict. So they can ask for the original phone or the original device data where possible. Um, can check who controlled the device, insist on the metadata for that matter, timestamps, any chain of custody. So compare the chat with that chat with Caesar memo. So FSL record, FSL report, call records, location data, or a recovery evidence, and be cautious about a screenshot alone, because screenshots can be edited or selectively presented. So the current BSA certificate format itself points towards these safeguards by requiring the identification of the electronic record, the manner of production, the device particulars, and even the hash value style device details in the schedule. So all of these come into picture. Um, I would rather say WhatsApp chats are not useless in courts, because they can matter a lot, but the law does not treat them like an ordinary spoken words, because a chat is electronic evidence. The court must first check how it was taken out, from which phone or device it came, and whether it was properly certified. Today, under India's new evidence law, that issue is dealt with under the Bharatiya Sakshya Adhiniyam, not just the old Evidence Act. And the idea is very simple: if a message is being used against someone, the court must be sure that the message is genuine, complete, and not manipulated. And that is why an original device, proper custody, and a certificate become very important. So, in NDPS cases, a WhatsApp chat can support the story of the prosecution, but usually it not stand alone, because it becomes very strong when it matches the recovery, or the forensic report, or the call details record, or the location data, or some other independent material. So, in short, a chat can point the court towards the truth, but it should not be treated as the whole truth by itself. It can harness the truth. It is more of like a motive, but until it is shown that it could be a supporting document which supports the actual crime, but it should not be the whole truth by the very nature of finding a chat which shows a motive, because motive is not the crime.